The pretrial chamber's decision that it was not in the interests of justice to authorize an investigation in the situation in the Islamic Republic of Afghanistan was based on the following three considerations, among some others, but these are the main three. The fact that significant time had elapsed between the alleged crimes and the request, the likelihood that relevant evidence and suspects would no longer be available, and the lack of cooperation obtained by the prosecutor. The prosecutor argued that these are broader considerations that did not need to be analyzed in this instance. We disagree, because the lack of cooperation in this case was actually based on general principles of customary international law and specific treaties between the United States and the Islamic Republic of Afghanistan. In her appeal brief, the prosecutor argued that the pretrial chamber was wrong in prejudging or speculating about the prospects for state cooperation. In paragraph 126 of her appeal brief, the prosecutor contends that some evolution over time may occur concerning the cooperation of state parties which are not parties to the statute. That is simply not the case regarding the United States. The United States has repeatedly and forcefully explained why it will not cooperate. As early as 2002, the United States Congress passed explicit legislation with wide bipartisan support, the American Service Members Protection Act, codifying into law that it will not participate. Under Section 7423B of the Act, and I will quote, "No United States court and no agency or entity of state or local government, including any court, may cooperate with the International Criminal Court in response to a request for cooperation submitted by the International Criminal Court pursuant to the Rome Statute." There is no room to speculate that this will suddenly change. This court's jurisdiction is based on the delegation of authority by state parties. However, there is no customary norm whereby states can delegate their criminal jurisdiction over foreign nationals to a third party. In fact, the customary norm is just the opposite. Such delegation is unacceptable. A state's criminal jurisdiction over foreign nationals is a bilateral issue between the state and the accused person's state of nationality. A state cannot delegate that jurisdiction to another state without the consent of the accused states of nationality. A state also cannot delegate its criminal jurisdiction over foreign nationals to a tribunal whose jurisdiction has been rejected by the accused person's state of nationality. For such a delegation to be recognized as a customary norm, it would require a widespread consensus of states. No such consensus exists. We further submit that it is not in the interest of justice to proceed against United States nationals in this matter because Afghanistan has no jurisdiction to delegate to this court as it relates to the United States. Article 34B of the Vienna Convention expressly provides the default rule for situations such as this one, the attempt to impose a multilateral treaty obligation on non-party states. And I quote, "The treaty to which both states are parties governs their mutual rights and obligations." This provision embodies the bedrock principle of lex specialis, and in this instance, the bilateral jurisdictional agreements between Afghanistan and the United States are the lex specialis that govern their relationship. The legal representative for victims 2 stated that the Islamic Republic of Afghanistan, in their submissions, has made no representation about taking legal actions against U.S. military personnel. The truth is, under these bilateral agreements, multilateral agreements, the interim security force agreements to Afghanistan, that jurisdiction rests with the nationals. In this case, in talking about the United States, of course, it would be the United States. On January 4th, 2002, the Interim Security Force to Afghanistan, commonly known as ISAF, signed a comprehensive agreement with the interim government in Afghanistan. Section 1.3 of the agreement's annex states that ISAF and supporting personnel, including associated liaison personnel, will under all circumstances and at all times be subject to the exclusive jurisdiction of their respective national elements in respect of any criminal or disciplinary offenses which may be committed by them on the territory of Afghanistan. The United States was a member of that group. Afghanistan also entered into bilateral state-to-state agreements with the United States, affirming that Afghanistan ceded exclusive jurisdiction over United States forces to the United States. The first agreement was a series of bilateral diplomatic notes that took effect on September 26, 2003. Second, Afghanistan entered into a bilateral security agreement, known as a BSA, with the United States in September of 2014 that effectively continued the ISAF agreement's terms. Notably, the pretrial chamber failed to even mention the ISAF agreement. In paragraph 59 of its decision, the pretrial chamber also incorrectly labeled the entire bilateral security agreement as an agreement pursuant to Article 98. This was incorrect. Article 98 agreements only cover the surrender of persons to this court. Both the ISAF and the BSA are much broader in scope because they also gave, again, exclusive jurisdiction over United States personnel to the United States. It is not in the interest of justice to ignore customary international norms. It is not in the interest of justice to override explicit agreements between sovereign states. And it is not in the interest of justice to waste the court's resources while ignoring the reality of principled non-cooperation. Thank you again for granting me leave to appear, Your Honor.
You've confined your arguments and remarks for the main part to the position of the United States, and particularly the bilateral treaties. What of states other than the United States of America who have security forces in Afghanistan, some of whom are signatories to the Rome Statute?
Well, first, there are governments that are signatories to the Rome Statute that are also part of the interim security force agreements. If there was a conflict between those, that would be different than in a situation in the United States. The jurisdictional grants, or the ceding of jurisdiction, was a negotiated issue. And there was additional, that's why I'm saying it's not just the international security force agreements. We had bilateral in the United States, had bilateral. And other governments may well have too. But in a situation that we have, it's clear that there was no jurisdiction for Afghanistan to cede to this court. If they were in fact parties to, it would be almost the opposite of lex specialis if in fact they were bound to a multilateral treaty like the Rome Statute. But that's not the case for the United States. And I should add that the annexes to the agreements are different for some of the various countries. For instance, as it relates, again, to not belabor the point, as it relates to the United States, it is an exclusive grant of jurisdiction from Afghanistan. Other countries, it may not be. So if there's a conflict, customary international norms you would determine based on interpretation statutes of treaties how to handle that. In this case, lex specialis would be clear, but it's also clear that Afghanistan did cede exclusive jurisdiction to the United States.